Hello. Hello, Miss Denise. You're on mute.
Hello, how are you?
I'm good. How are you today?
I'm good. It's been a hectic day today.
I know. I feel
Lots
you.
Yeah, lots and lots of movement at the courts and stuff over the last couple of days. It's been a little crazy.
Yeah. So we tend to start these out. I'll do the typical introduction that I have proofed before.
Okay.
And then we'll kind of open it up to possibly some questions, and I'll ask you to kind of go over some stuff that may have happened over the past week, and then we'll open it up for kind of questions.
And I've not met this other attorney before.
Blythe, I guess, does a lot with Lauren in Tucson.
Okay. Okay. I was like, I don't even know who that is.
Mm-hmm.
And you've done these every week, so basically, is it just like an open forum? People just ask questions.
Exactly. Mm-hmm. Yeah.
Okay. Try to get interaction. I just finished a School of Real Estate one for 3 hours, and there were 183 people. 183. That was a unique way of dealing with questions from them. It was difficult because there were so many people, and so eventually I just went, let me finish this real quick and then let's start doing your questions, because it was obviously a lot of people who.
So did they run it like a town hall like we're doing now rather than a webinar like we did yesterday?
No, they ran it like a webinar, and so I could see the number of participants, but none of them, we didn't see their faces. Did the share screens? It was more like that. So with that many people, you almost have to. But then they had 2 people moderating the chat room because they were coming in so fast. There were so many comments. I think at the end there were more than 600 comments. So the idea was like, a lot of them were kind of at the same questions at the same time, so they were reading them ahead of time so that I didn't have to do that. That was very
that's good.
Very helpful.
Yeah. Yeah.
It's like Mary Alice is trying.
Well, we just did the leadership webinar.
I know Andy couldn't get on. I am so bummed because I was teaching and I was like, no, somebody go and take notes. And then at lunchtime we were doing.
Well, you know what, Denise, we're going to have it available on our website. We videoed it.
Oh,
so
good.
If you guys want, we're gonna have that probably check back in next week.
Okay.
So you can kind of see what we have. Mark Dwayne, he does the PMP stuff, and then we had Natalie Evans from CoStar. So it was good.
Nice. Well, God, you had so many people signed up. It looked like a really great group. Looked really great. Yep, I was very bummed. And I actually was saying, is there a way I could, and they're like, no. Look, okay. Just thought I'd ask. Just in case. Yeah.
Okay.
So I'm going to go off video here just for a second. I'll be right back.
You're fine. You're fine. Hello, Blythe. I think you're on mute, so you might want to just unmute yourself.
There we go. How are you doing?
There you go. I'm doing good. So Denise was on just a second ago. She'll pop back on in just a minute. So kind of how we've been running these, I'll do a short introduction. I'll share my screen, and then we'll ask you guys if there are any updates to update the group on this week. And then we'll open it up for questions. I do have a couple canned questions that I'm going to pull up just if I need to get the conversation going. But thank you for doing this for us.
Of
We
course.
really appreciate it. These have been particularly popular, so it may be something that we'll continue to do into July. So.
Oh, good. Yeah. And well, stuff's changing so quickly right now. So.
I know. That's exactly it. You got it. So yeah, I'll pull that up in just a minute. So yeah, and I'm gonna, I'll share my screen and just see if I can do that.
What are my updates this week?
There we go.
Oh, fun. What has gone on this week? Now I have to think back to what.
I know. I know.
I don't know what happened this week. Okay.
All right, I'm going to stop sharing for a minute so I can admit people. Denise, Holiday, meet Blythe. Blythe, meet Denise. Denise is with our Phoenix, Holiday and Holiday. She's.
Yes, I know well who she is.
Okay, good.
I'm surprised we've never met before. At least I don't think
I know.
we have.
I think we've crossed paths probably in courtrooms or hallways or something, but yeah, we've never been at a function together before. So.
Well, I don't get down to Tucson a lot. We send Matt.
Yeah.
That's most of our courts down there. Yeah.
Yep, I see Matt. And I don't get up to Phoenix much because you guys cover Phoenix. So.
Yeah. Yeah.
Yeah.
Oh goodness.
Although finally the Tucson courts are starting to move, which is.
Oh my God.
Yeah, breath of fresh air. Finally, they're going to start doing their job.
I just had a nice big blow up with Javier, one of the admins at the Justice Court yesterday. That was oodles of fun.
Well, that's the issue, and we all agree that the admin staff is
Oh,
like that. You'd think that they were the soldiers to the kingdom or something.
I'm getting ready to write letters to the Pima County Board of Supervisors, I've tried the presiding judge, he doesn't, and the Justice Court, he won't respond, so.
Send it over to Vince.
Oh, that's a good idea.
Yeah, you know, he really seems to be the most reactive to some and gets on top of it faster. Yeah.
Yeah, and I've talked to him quite a bit about it. Yeah, I mean, we're just.
What I find is that he typically takes whatever we send him and then he incorporates that and then sends out to all of the judges, which is however he wants to do it. I'm thrilled because ever since he got there, he's really helped increase the level there.
He's definitely our best advocate. But yeah.
Well, I don't know you know his story either because I taught with him as a constable for years and he would complain, I was complaining, and finally I said, look, go run.
Go run.
You know, the whole idea is just go run so you can save us.
Yes.
And he did, and he went, oh, this is a lot harder than I thought. But Robert says he's done a great job. Been very proud of him. He's done a great job.
He's fabulous. No, yeah, and his background. I was laughing because I was in front of him the other day, and I just put up some curtains in my office to hide. I have like a little kitchen area there. And he's like, oh, you blocked out your fridge. I'm like, you noticed. Well, my previous life, I'm like, I know, you noticed everything.
That's funny. That's very funny.
It was worthwhile. As Robert's noticed. Oh, gracious. Well, how are things going up in Phoenix? Are you guys getting, I mean, I know you're always better run than we are down here, but.
You know, they're very efficient. Whenever we have a problem, like I'm the president of ALTA, which is the attorneys. By the way, feel free to join us anytime. It's a free membership. It's all the landlord tenant attorneys throughout the whole state. So just send me an email and remind me. And so every time there's an update with anything we know about in the court system, I blast it out. And I'm getting ready to do that today based on best practices that we'll talk about here in a minute. But I also then got this huge, almost like hit list. Here are the 14 courts that are running inefficiently and why. I'm like, okay, I have to write an email to their bosses and let them know what they're not doing. They're doing these weird things where you drop it off kind of like they do in Tucson, and then not letting you pick them up for days, but then not putting in a correct court date. It's too soon. So by the time you get there, I'm telling my runners, don't leave the building. If you know it's not at least 5 days, don't leave the building unless you have a corrected date. Yeah. The problem is everybody could shut down. They're not letting process servers go into the main area. And so, but that's one of the things I have to do before the end of the day is say, look, this has got to be fixed because you're cheating the statute and you just can't.
Oh yeah, we have that problem too. I know a couple cases I had a couple days ago. They stamped them on the 22nd, set them for the 25th, and they weren't available for my runner to pick up until the 23rd. And of course from Javier, I get the big runaround about, well, we have this very complex calendar and it's so hard. And I'm like, Javier, it's not hard.
Right.
You have to get in the 3 to 6 day period. I'm like, well, you're not getting it in the 3 to 6 day period. You're cutting it short a day. So.
Yeah. I see we have some people who've joined us.
Yes.
Hi.
Hi, Debbie. Who's Debbie? But Debbie, I don't see a face.
Oh, because I turned my face off, Denise. Here, hang on a second. Debbie from over here at San Montego.
I thought it sounded like your voice.
How are you doing?
I'm good. I'm good.
Thank you for doing this. Are we okay to ask you a couple questions?
I don't know. Michelle's in charge.
Oh, Michelle.
I'll probably hold on just a minute because she's going to start things, I think.
All right.
Yeah, I'm gonna start things off in just a few minutes. I'm waiting for folks to just jump on, and then I'll do the introduction quickly, and then save your questions because we've got two great attorneys here who have all the answers.
Thank you.
All of them, Denise. We have all of them.
Every answer you could possibly need, and some you don't want.
Unfortunately, yes.
Okay.
Mary and Tammy and look at everybody. Nice.
It's a party.
Right. Well, I'll go ahead and in essence of time, we want to make sure that we keep on track a little bit today. So good afternoon and thank you for joining us for our AMA Education Town Hall today. We'll be featuring Latte with a Lawyer. Our education team has put together several webinars for you during the month of June and July. Our next session will take place on Friday, July 10th, featuring Secrets of Leasing Leaders. You may register on our AMA website. I would now like to take the time to remind you that during this challenging time, our vendor members are there for you. They are ready to work with you on whatever budgeting restrictions you may have or emergency services that you may need. They have been your trusted suppliers and would like to continue to provide you excellent service at any time. A few of them are identified on this slide and live by the motto AMA Members Supporting Members. I would now like to introduce our special guest panel for today's Town Hall webinar. Please welcome Denise Holliday with Hull, Holliday & Holliday, and Blythe Edmondson with the Edmondson Law Group.
Hey, everybody. I see you ahead.
Welcome, guys.
Hello. Do we have
Do
any?
you want to drink a latte?
Yes.
Do we have any Pima County folks on the call? So I know if I need to address any Pima County issues.
I'm not sure.
Okay.
It doesn't appear as though we have any.
It doesn't look like it, but I was just.
Well, MC Residential's down in Tucson too. I don't know.
Yeah.
It just says MC, so I don't know who it is yet.
So this is your time to ask some questions of Blythe and Denise. I will pretty much start by asking Denise and Blythe if there's any kind of information that they can share with us about some things that have happened this week. As you know, things change constantly, daily, and we always like to provide some type of update, and then we can jump into all of your questions. So I will let Denise start. Has there been any new information or things that have come out this week that you'd like to share?
Yes. In fact, if you'd asked me yesterday, I'd say no. But last night, about 6 o'clock at night, some final decisions were made by the Best Practices Committee. What that is there's a group of judges who sit on some work groups, and they do them all over the state. And this is specifically was the Maricopa County work group. And they came out with some policies of how they're going to interpret the CARES Act. If you're not familiar, hopefully you're familiar with that, but the CARES Act is a federal law, and part of that federal law issued a moratorium on evictions for non-payment if you are federally subsidized loan, if you are a subsidized property, or if the individual tenant is a Section 8 or voucher recipient. And as such, because it's been a little gray on what happens when that expires, presuming it expires, which it does on July 24th, or 25th, I'm sorry, the idea is what's going to happen. And there's just not been a consensus. And it's hard for lawyers for us to tell you what you need to do when 50% of the people say something, or even 60%, and some say other. Then our job is to say, well, here's the two views. And as of yesterday, I was still telling everybody, here are the two views. However, those views have now been dramatically narrowed. In Arizona, when you terminate a tenancy for non-pay, we usually give a 5-day non-payment of rent notice. Under CARES, there's some odd language that says at the end of CARES, before you terminate that tenant's lease, you have to give them a 30-day notice to vacate. And so the question was, well, that's a non-renewal notice in Arizona under a specific holdover statute, 33-1375. So the idea was, does that mean our 5-day non-payment of rent notice is now a 30-day notice? Half the people said, absolutely not. That's a misinterpretation. The other half said, gosh, we think it might supposed to be because this was a national act. And the judges chose the safer version of that interpretation, and they've decided that the guidance in Maricopa County, which probably will then flow out to all the other counties, is to require a landlord who wants to terminate a non-payment of rent case, specifically non-payment, has to give a 30-day notice to pay rent, and you cannot give it sooner than July 26th, which happens to be a Sunday. I'm sure all the attorneys that are involved will create their own notices. I know the AMA is going to do that too. And so you don't have to create one on your own because there's some special language. You can't charge late fees. If you want to non-renew a lease under CARES, if you're a CARES covered property, you can't issue a non-renewal notice until that same day. It's still a 30-day notice because it didn't change Arizona law at all. But remember, in Arizona, it's 30 days from the next rental period, and you have to add 5 days for mailing. So if you wanted them out by the end of August, you're going to have to, on Sunday, issue that notice. Even though it's a Sunday, you're going to have to go deliver it to them or minimally send it certified mail. Even though the post office is closed, you need to put it into the mailbox that day. And that's the biggest thing that's changed our industry in the last few weeks, besides all the chaos of CARES, of the virus. Blythe, how about you guys down in Tucson?
Down in Tucson, we're far more hectic and less organized than Maricopa. So they do generally try and follow Maricopa. So again, when we get that information, we try and get it out to the judges and the constables. Right now, one of the biggest changes to be aware of is as of the 1st of July, we will no longer have the pro tems hearing our eviction cases. It's going to be actually the elected JPs. Some of them have been trained and some of them, I believe, have not been trained. So there's going to be a little bit of a learning curve there as we try and educate all of them, quite frankly. But just be aware, again, that's going to be coming up starting July 1st. So if your attorney says, hang with me, we're educating a judge, we're getting through this, hold tight, we're working on it. And that'll be a change for us. The constables down here continue to be very scattered as to which rules and which provisions they're following. There are some that are going ahead and issuing the writs without, as long as they've got the order, without much follow-up with the tenants. Some of them are giving the 5 days to provide information regarding COVID exposure or something that falls under the governor's executive order that would qualify them for the stay of the writ. So that's what we're seeing in Pima County right now.
So it's interesting up in Maricopa County, and actually in Pinal too, there's been still ongoing evictions for non-pay and for other issues. And by the way, if you're a CARES covered property, you can still do evictions for all other issues under the regular statutes. But we received some information last week about some numbers, and I'm going to pull those for you real quick. We're a little unique in that the number of evictions are down substantial, and they were comparing them to 2019 versus 2020. And in March, the numbers weren't really that much off, less than 20%. But then when we got into April, we saw more like 60% and then like more than 70%. And they gave some statistics about the motions to compel. Motion to compel is when a tenant tells the constable, hey, stop, I'm covered by the governor's order, which is basically a slowdown order telling people that if you are sick or have lost your job or are otherwise impacted, there's some 5 categories, provide that documentation to your landlord, and then the writ will be slowed down and they may not lock you out for weeks or maybe even till the order expires on the 23rd. So that was a little gray, and we discovered that there haven't been that many. At the time we got the report, which just through May, there was only 31 motions to compel that were not granted. So I would encourage you as a landlord, if you're getting information from your tenant that says, hey, I'm impacted by this, talk to your lawyer. Don't just decide on your own, or talk to at least your regional or somebody who's the next step up to see, should you be entering to payment plans? It's going to be an interesting question, since a lot of these orders are going to be over near the end of July. Are you going to let those repayment plans go much past that time frame? I can say most of our clients have said, we're not going to let it go that far out. That might change with this new interpretation of what CARES requires. But if you're already in a repayment plan or a deferral plan, you can't force the tenant out of that. But if they're in breach of whatever that deferral or repayment plan, issue a brand new non-renewal or issue a brand new non-pay or a new partial payment agreement, whatever those factors are, so that you have a clean notice when you're going into the court system if you have to.
One thing we're seeing here too is people are falsifying the COVID notifications. So we encourage our clients, or we'll do it for you, depending on the case, follow up and make sure it's actually a valid notice that someone has COVID or that they've been laid off, because there are all sorts of great fakes out there. I even had one that came from Great Britain the other day, claiming they had gone to Great Britain and got it done. So
It's interesting. We've seen the same thing where it's a fake doctor's office, or it's a real doctor's office, but they faked the letter. And all we're saying is either email it or fax it to the doctor's office and say, we're just verifying that you sent this. Kind of like what we do already with reasonable accommodation requests for like an assistive animal. One of a good policy is just to send that form back to the doctor and say, hey, did you fill this out? We actually had a couple that came in that were faked from the VA. And I don't know why someone even thought to check it, but they did. And both of those, the two that we saw, were both faked. And the VA took some very strong attack of that particular issue and decided that that person now was in jeopardy of those services because they'd falsified basically a federal document. So double check with that employer, get online, call the business. Sometimes they were fired, last year, and they haven't worked there in a very long time. So make sure you're verifying that. Yeah. How about any questions?
We've got one question. What is the latest on the moratorium possible extension to January 1st?
I do not think there's any chance they're going to do that. That was part of the HEROES Act, and that was soundly defeated in the Senate. They didn't even take it up. The problem is, even though that sounds like a great idea, you can't keep owners in business if you don't let them have money. They can't pay their mortgage. And even if you do a mortgage deferral, it's not going to stop the fact that they can't pay for the common utilities. They can't pay for the staff. They can't pay for the repairs to fix the toilet. They can't pay the vendors to come and do pest control. So while that sounds like a great idea, hell, let's help everybody and give them free rent. The realistic part of that, since all of us are in the industry, is if 10 or 20 or 30% of your tenants don't pay rent, the margin, the profit margin is so small in multifamily that it just is not realistic. And I can tell you, I don't think that's going to happen. We don't know if the governor is going to do an extension. He's been spending lots of times asking and taking comments from all the stakeholders. And there's a lot of information. If you're in property management and you care about that, you have a voice. We would encourage you to use that voice and get a hold of the governor's office. Please be respectful, by the way, if you do that. And just tell them your story. I mean, one of the things we've tried to share is, while that sounds like a really good idea, here's what we're seeing. You have a 20-year-old who says that they have diabetes, but they're going to work and they're going to the bars and they went to Vegas and they haven't paid rent in 4 months. That's not who the governor intended on protecting when he said, if you have a special health issue that makes you more at risk. We're talking about people who really can't leave their home because it's too hard and too risky. But if you're going to Vegas and you're going to bars, that's not who the governor intended on protecting. So if you have some special stories, especially if you could let the AMA people know, we're trying to gather those to provide that information to the governor.
I agree. I don't think federally they're going to extend anything. And I think statewide, we need to, again, keep reminding the governor of what you guys are looking at and what you're facing, because the more information we can get out to him and the public just on the status and how this affects you guys, it makes a difference. I think if he tries to push it out at this point, there will be the governor on the statewide level. I think there'll be a pretty big outcry.
Yeah. We've actually had several clients who are talking about filing suit if it goes out. They've been very patient. Arizona, we're different. Even when we protest, we don't burn down buildings. And so we're asking for him to treat us just as respectfully. We're the only industry that's had to continue to supply a service and not get paid for it. The restaurants didn't have to close their door and still feed people. And the stores didn't have to close their door and still give the free services. And that's been our concern, is we've been trying to help them understand we still have to provide those common utilities. We still have to provide the fixing the toilet, fixing the AC, all the normal stuff that we do, even just the utilities at multifamily sites. It's very, very large every month. And we need that income to be able to pay those bills and keep people involved. And we've got quite a few extra people just joined. Hey, everybody.
And it is, again, arguably a constitutional taking of property. So there's some strong potential in those claims.
So Denise and Blythe, there's another question. Do you recommend closing, I'm sorry, now I'm getting questions. Do you recommend closing amenities once again now that the cases are increasing so rapidly and consistently?
I can tell our firm is not. Part of that is because there was a class action filed. against a multifamily company for not opening, and basically the argument, I'm not getting what I pay for. Luckily, most of our leases say, look, if we close an amenity or limit the hours, that doesn't impact what you pay for rent. That being said, we're trying to be very mindful of that. I think maybe putting in back some more restrictions, removing the pool furniture, removing some of it out, and then marking it on the pool top to say, don't move this, putting up good signs, having some good cleaning stations, setting some protocol in place. I think that having those things and that criteria and that protocol will help you if someone claims that they got sick at your property. And you do need to do something, but I think a complete closure at this point is probably not a wise thing. I think you're basically asking to be someone who's going to be sued. What do you think about that, Blythe?
I agree. And again, reminding tenants in newsletters or however you communicate with them that, there is a risk and that they do need to follow these protocols when they're using the common area. Make it part of your rules for the common areas or for the amenities. That again,
Blythe, are you encouraging your clients to create waivers? So something like a common use waiver that says that you recognize that these are the risks, that they agree and sign off that no one is sick, they agree to report it right away?
I like waivers for that purpose, and we encourage it. The only thing is, again, enforcing those is generally very difficult. So I let my clients know we encourage the waivers. That's a great idea. We want to see them do that because I think it makes tenants think twice before they go ahead and file a lawsuit. It encourages them to be aware of the risks. I don't think the waivers actually ultimately are generally very beneficial as far as staving off litigation if the lawsuit is actually filed. But again, yes, to get tenants to think about it, I think it's a great tool.
So to that point, here's another question. We are in the process of reopening our amenities. We now require that residents sign a COVID-19 disclosure addendum. If they refuse to sign it legally, may we refuse them access to our amenities?
That's a fantastic question that no one has an answer for. Unfortunately, I mean, I can tell you the problem that you have is there's a statute that says you can't materially alter a lease agreement during the lease term. We know that. You can't suddenly put a $400 pet fine in or something. And by saying you have to sign this, or I won't let you use what's already listed in your lease, is probably not enforceable. It's encouraged, but I would tell you, I personally think that you can't force them to sign it. It's different if you have a brand new lease, and make sure you're talking to your attorney, because we have a statute 33-13-15 that says thou shalt not include terms in your lease agreement that attempts to exculpate or eliminate your liability. Yeah, that's pretty much what a waiver is. But the idea is that you can couch that language carefully. That's what lawyers do. So you can still include it, but you're not violating the law. So I could tell we have said encourage them to use it. I don't think you can refuse to let them have access to areas like the postage area, your mailbox, and I just don't think you can. I think it's probably not enforceable. Blythe, what do you think?
I agree. I think again, waivers are great, but I'm encouraging my clients to lean more towards notices. Again, if you can get the tenant to sign off on that much better. But again, if they don't sign it, you're kind of stuck because that is a change. Again, things like changes in rules. So again, they're required to social distance. Those are things you can provide notice for that isn't a material alteration of the lease. Again, the social distancing, things like that. But to actually restrict them from using something if they refuse to sign a waiver of liability, I don't think that's going to hold.
Yeah, I can tell you, I think that if they're just applying and you get a new lease, you can. I also think that if you're going to be showing the property, that you can require that. The question we get is, well, we're worried about sending our staff in to a unit where they won't disclose on the work order. And I think it's very reasonable to include on your work order request, is anyone sick? Has anybody been tested positive? We know some clients are actually taking a temperature, and there's a fear potentially that maybe you're getting close to like an issue that's a privacy issue. We say HIPAA, but HIPAA doesn't really apply to us because it basically only deals with medical groups that have that information, but it's still a privacy issue. And so I would tell you, be careful, talk to your legal counsel about what that looks like. If you're going to take a temperature before you go in, and do a work order, if you're going to make them sign something saying they tell you that they're not, they avow, we use that phrase, that no one is sick, that no one's tested positive, that they haven't been exposed. But also it says that they agree to stay more than 6 feet away, that they agree to leave the room while the vendor's there. And in exchange, we tell them, we will make sure that our people have the proper protective gear also, because we want to keep you safe and our staff safe.
I agree. Short sum up there.
Okay, so with a 30-day notice to pay, how does that impact August rent? Can late fees be charged on August?
Yes, CARE says that it expires on July 25th. And so in theory, you could charge rent, late fees for the 26th, 27th, 28th, 29th, 30th, 31st. I think there is this gray zone. Did they intend, when they say you can't charge it, that it's waived permanently for that period of time from the March 28th to July 25th? I think the conservative view is yes, that it's permanently waived. You don't just back it on to the end of the ledger. It just says you can't charge it. So I would say, as a reminder, you can't charge a NSF or a 5-day notice fee, which many of us have, because that particular rule, that part of CARES section 4024 says you can't charge any late fees or any other fee associated with a non-payment of rent, which would be a notice fee.
Yeah, I've been telling my clients, again, it's a gray area, but consider late fees waived for that portion of time. And you're starting up again in August with late fees.
Okay, here's back to the CDC. We posted additional pool rules keeping in line with CDC recommended guidelines. If they fail to follow the rules, what legal recourse do we have, if any?
If you've given them notice of the change of rules and they've had sufficient time for those to be in place, then I think you've got a non-compliance issue. And you can go ahead and give them a 10-day for non-compliance.
And I would say, I think the 10 days the better. The question we had too is like, could I give them a 5-day health and safety? Be careful. That's really for, let's say they test positive and they test positive and they've told you and you have that information, and yet they are going out to the pool area and 5 people from that family are all sick, they're hacking and coughing. That would be a 5-day health and safety. But everything else, a general non-compliance for basically anything that's not a health or safety level is going to have to be a 10-day, including for CARES properties.
Okay. What can you do if a resident has tested positive and refuses to stay out of the common areas?
I think what Denise just said is, I think, again, if you're, keeping privacy issues in mind, if you're well aware that that's the case, then you may have a case for a 5-day health and safety notice.
We actually had
it would be it'd have to be health and safety because it's.
Yeah, we actually had an odd one in that we had a person who was sick, tested positive, was very, very, very ill, and came into the office hacking and coughing, telling everybody you can't do anything about it, spit on a desk, hey, I'm sick, you're all going to get sick too. We treated that as an immediate because you're intentionally violating. Arizona has a state law that says if you have a communicable disease and you're quarantined and they had received a quarantine order from their doctor and you violate that, that's actually a criminal issue. And so we took that and we actually won that because that the person said, yeah, if I got it, so everybody else should get it. Look at how sick I got. I missed all my work. I missed all this money. I think I caught it here and I'm going to give it to everybody. And I think, but that's very, very, very rare. But given those set of circumstances, in theory, that might be enough.
I think in general, the courts are pretty good about protecting property managers. Again, if someone's threatening staff, at least I can speak for the Pima County JPs, they tend to take those seriously. They're not ignoring those. They're saying, oh, it's a minor thing. They pay attention to those.
Yeah, the same thing in Maricopa County and in Pinell too. Yeah.
All right. Jeannie has a question. My property is not federally backed, no mortgage. We are able to evict. Can we bill back fees?
Not sure I understand the bill back. So did you tell the tenants you were going to waive the fees? If so, you've already told them you were going to waive. If you just didn't do anything, and we've got some larger apartment communities that just made the business decision that they didn't want to be on the front page of the newspaper. And so even though they don't have any federal funding, they decided to waive late fees and not to do any evictions until July. And so since they told the tenants, hey, we want to work with you, we're agreeing to waive this, they can't go back and charge that now. But if you didn't do anything about it, just because you were trying to be nice, but you never told them you were going to waive it, absolutely you could do evictions now. They never have been stopped. Under certain circumstances, the lockout, the writ of restitution might be slowed down. It requires specific issues that involve the tenant. And I can say that's the kind of hard part, I think, for a lot of people to understand. CARES is completely irrelevant to what the tenant circumstances are. It only addresses, does the landlord have a loan or is there a voucher? Completely irrelevant if the tenant has plenty of money, just won the lottery, it doesn't matter. They don't have to pay and you don't do anything about it. Different from the governor's order. The governor's order says, landlord, you can still go to court and get your eviction. We wish you wouldn't, but constable, don't you dare lock that person out. Take it back to the judge and have a hearing if the person thinks that they've been impacted by COVID under one of these ways. And those are just really different. But if you're not under CARES, absolutely give your regular notices and let's move forward. You really want to do it sooner rather than later because you want to be ahead of the very large groups that are probably going to be coming along once all the things open up.
Another thing to be aware of too is I know with some of my clients, we're walking into court and we know that the individual has been impacted by COVID. And a lot of my clients are agreeing, hey, we'll agree to go ahead and push the writ off until late July. And that way we don't have the issue with the constable having to do another hearing, that sort of thing. So again, if you know you have someone who's been impacted by COVID, one option to kind of doesn't really speed things up, but it eliminates a lot of the hassle and a lot of the extra paperwork is to just go ahead and agree to the later writ date. And again, that falls under the Arizona provisions as opposed to the CARES Act. But most of my clients, again, either they've stated that they were waiving fees, in which case you can't go back and recharge, or they've continued charging them essentially all along if they're not under the CARES Act.
Hey, Blythe, something interesting that I should probably share with you as part of that best practices that came out is how do we deal with the cases where we already got a judgment in March or in April or in May or even in June, and they didn't do the lockout because the person said they were protected by the governor's order. And the general consensus has been that if it's less than 45 days, then since you got the judgment and you think that they're no longer covered by the governor's order because they're not sick anymore, they're working, whatever that issue is, then if it's less than 45 days from judgment, go ahead and apply for the writ. If it's more than 45 days, you're going to have to come in, and it's interesting, they want you to file what we call a combined motion, a motion to amend the complaint or the judgment to include the after accruing rent. So if you got a judgment in March, so now we would do a motion to amend and add, April and May and June and potentially July to it so that you don't have to go back and file a brand new eviction. And also a motion to compel the execution of the writ, letting the judge know that you haven't reinstated the lease, you haven't signed any new agreements, you haven't taken any partial payments. So there'll have to be a hearing on that. And so that's a real good idea, Blythe, that if you're going into the court system right now, we're so late in that process, you might want to voluntarily agree to put the writ date out, because then you don't have to have any kind of new hearing.
Right, but thank you for that update, because yeah, the 45 days, again, that was one issue we were facing early on was, the writ's good for the 45 days or the specified time period. What about after the fact, if we haven't delayed the writ, if we haven't agreed to that? So thank you for that update.
So some of you might not know that. So there's a rule that says, in the event that the writ of restitution is not applied for after the judgment, if it's after 45 days, then the landlord has to sign an affidavit that says that there's not been any undue delay for any inappropriate purpose, and that we haven't reinstated the lease, and that I still need the valid writ. It's not necessarily that the writ expires, it just requires some additional avowals to the court and some additional paperwork and probably a hearing. No questions?
Those are all the questions that that we have.
Hey, since we have Michelle, since we have a second, one of the things I'd like to remind everybody, and this just kind of got overlooked because COVID hit right about the same time. On January 28th, a really wonderful HUD memorandum came out that really helped clarify what to do with assistive animals. It's a great memorandum. So look it up. I know that the AMA has it on the website and we have it on ours. I'm sure most attorneys do. But it was a really big clarification. And if you didn't know that, you really should go back and read it. It actually has some interesting new guidance. Like one, normally we know that there's an unauthorized animal when we hear a dog bark or we go to do a repair and somehow they're not picking up the poop, something, right? So we give a 10-day and they come back and go, King's X, hold on, it's assisted animal. And this memorandum clarifies that the timing of their notification that it's an assistive animal may be suspect, but you can't deny reviewing the process and engaging in the interactive process simply because they asked too late. So, and that's kind of a new thing for us. We wondered about that. It also had this great language that said an online doctor is not appropriate. It probably isn't enough. You have the right to ask where they've met, like the location of the doctor's office. And if it's in another state they've never lived, that's probably suspect. It also encouraged all landlords to start keeping a list of all the accommodations or modifications that you grant. We've always recommended that, but that was really nice to hear that they think that's a good idea. The reason why you do that, guys, is really kind of cheating. Not if, but when, because eventually everybody who's in the industry, if you've been doing it 10 years, you will get a fair housing complaint. And if you're keeping a list and someone says, you treated me differently because I was disabled and you didn't let me have the whatever, you say, here are all the other ones that I've granted in the last years. And so if you want to go backwards and try to find those modifications, remember modifications is changed to a thing and accommodations is changed to a rule. I always say my little phrase is accommodation involves a rule, modification requires a tool. We think about that because a modification is physical change to a thing, and you can require the tenant to pay for it. It's like a grab bar. Sometimes you guys do it anyway because it's just inexpensive and you want to make sure it's done properly, but you should be keeping the list of that and keeping a list of who you transfer to a different floor. That's considered an accommodation. Assistive animals are by far the number one, but if you haven't read that, you really should, because it also says if a tenant asks you for an accommodation and you are going to say no, before you say no, you got to send them this paperwork. And it's at the very end of, it's like, I think the last 2 or 3 pages of that memorandum. You need to give that specifically to the tenant or send them the link before you say no. And our theory is don't say no, say, I'm not able to process your request right now because I'm missing the following information. Just like we don't deny an application to reside here because they don't have their payroll, we say, I can't process it, right? So you're not saying, you're saying I can't. I need help from you.
Yeah, we were all excited about that memo and then COVID hit.
Yeah, exactly. Days later. Any questions?
All right. Any more burning questions out there? I don't think there are any.
We are so good. They know everything. They're now going to go conquer the world.
Trained everyone.
You answered all the questions. I told you had all the answers. All right. Well, we will let you guys go. Thank you, Denise and Blythe, so much for jumping on with us today. This has been one of the more popular webinars that we've been doing, and we'll probably continue to do this into July. So all of you keep a lookout for our email blast, and we will get you the information to sign up for more.
Everybody
Thanks,
have a good
ladies. We
weekend.
appreciate your time. Have a good weekend.
Stay safe.
Thanks. Bye-bye.
Any follow-up questions, shoot us emails.
Yep. Thank you.
Thanks, guys. Bye-bye.
Bye.